Welcome to 5 at 5 with Stone Law Offices. I'm attorney Brendan Bybee with 5 minutes on choosing guardians for your minor children. One of the most important decisions that you make when putting your estate plan together is deciding, more importantly than who's going to be in charge of your money, but who's going to be in charge of your family. Who's going to take care of your kids when you're no longer there? Now, hopefully you're going to live a long life. You're going to be their guardian throughout their childhood and see them well into adulthood. But for too many people, that is not the case. And if you fail to provide for that, then the question comes up in the air. Ultimately, a court will decide amongst those who come forward who is going to take care of your children for you in your absence, as well as who may be in charge of the money that you leave behind to care for those kids. So a very important part of your estate planning is to decide that for yourselves. Who do you want to have raising your children in your absence, in your inability to do so yourself? Now, this is a very tough decision. It's often one that couples will spend the most amount of time sort of talking about and determining whose family is going to take care of this. And sometimes they don't always come to the same conclusion and agreement on that. And I'll talk a little bit about that, hopefully, if I have time. But I want to talk about some other decision points there that you need to be aware of. First of all, deciding who is going to be guardians for your children, who you're going to name. There are a number of factors that you might consider. One is, how well do the kids know this person or these people in their family? Is there a prior relationship there where this is somewhere where they would be comfortable? This is someone who they know and they would trust. Are they in close proximity? One of the things that happens is obviously there's a lot of displacement when parents are no longer there. And so if you're talking about that, are they going to need to move in with this family? Who is it going to disrupt, and how much fallout is there going to be with that? Generally speaking, if you can keep them close to home, if they don't have to leave their school and everything else, the fewer things that are going to be disrupted, generally the better. But that might not be the most important consideration, but it should be part of your consideration. Another part of this is how well and how long have you known these people? How well do they understand you and your values? And how well do you think they'll handle knowing that you can't control every aspect of their parenting skills, of their approaches and philosophies? Do they know and understand and respect yours? And can you reasonably know that they're going to take care of your children in reasonably close to the way that you would hope them to? Now, moving on from some of those concerns, when we're talking about this, we're talking also about you've left all this property behind, whatever that might be. You've left it for the care of those children. Now, one important thing to consider is, are these people already named in your documents to act as your personal representative for your estate or a trustee for your trust? Are they going to be in charge of the money? And do you want those to be the same people that are in charge of the kids? Now, that may be the best situation for you, and a lot of times that's what I see clients do. But you may also consider, there may be people that you think are better at parenting than they are with money, managing money, and you might not want them to be in charge of both things. You can have additional oversight if you have guardians that are in charge of caring for the welfare and the education of those children, and another person who is acting as a trustee and managing those assets for the child, and can decide and help the guardians to be more circumspect about how they're using those funds and stay on a budget and approve those distributions. So that's often a very good tool there. And again, if you know somebody who's really good with the kids, but they're not the best with the money, then obviously that's a great choice. But in any case, it may be good to have the oversight of those things kind of being divided, so that the person who's in charge of the money is not necessarily the same person who's in charge of the kids. Some other considerations are, where do you do this? Where do you decide and name who's going to be the guardian of your children when you pass away, if they're still minors? And generally, we would do that in a last will and testament. Now, it could be anywhere in any kind of document. As with all things in estate planning, the primary question is going to be authenticity of that document, that it can be verified that you have named those people, and this is an authentic document. And so a last will and testament is excellent for that because it's something that gets authenticated in court, subject to a court order approving it, and therefore naming those guardians in there is often the best place to do that. So you do need to have an estate plan, though you can name them in other documents. Last will and testament is generally the best. Now, doing that, when you're naming them, there raises the question of, are you naming a couple? Are you naming an individual? Are you naming more than one person? Oftentimes, with everything else we name, where you're naming somebody to act for you as a trustee, as an agent, or under a power of attorney, we recommend that you name more than one person, that you have a few backups in there or successors that can take up that position if the person who's named there, they may not be in a position, though they were at the time that you named them, maybe they're not in a very good position to take that on. It's too much for them, and they prefer to decline, where there's somebody else named that is better equipped to do that. So it's important to have more than one in place. They may have be themselves subject to some to either to prior death or incompetency or something else that renders them unable to do that. Especially when a lot of times younger families will name they'll name parents, grandparents essentially, to be the guardians of those children. They may be too far in age at the point this comes around, or may have other issues with doing that. So it's important to think through that, to think, okay, if I'm naming a couple, does it matter if they're still married, if they are divorced, or if one of them is deceased? Are you okay with them being with one or the other? In which case, do you have a preference which one it is? If you prefer them to be married, do you have another married couple that stands in the wings as the next best option? It can get complicated. It should be thought through, and because these things are difficult, it's important to talk through them with and counsel with an attorney. Now, to briefly return to the question of, say, a husband and wife cannot agree, what happens then? Well, essentially, this has happened in the case of the member of the Beastie Boys who passed away, in that music group that passed away, and he and his wife did not name the same people. He passed away first, she survived. His guardianship designation doesn't matter because they're still with their legal parent, their legal guardian, and therefore, if she was to pass away and they were still minors, then it would go according to her designation. So they don't have to be the same designation, but you do have to know that essentially it's going to be whoever survives. If they pass away and they're still minors, then their designation is going to be the one that controls from that point forward. And that's 5 minutes or more on guardians of your minor children in your estate. Please let us know if there's anything we can do to help you make these tough decisions for your estate plan.